Good afternoon. Thank you all for being here this late in the day. We're sorry we couldn't do this earlier. Obviously, it's been a very busy day. For those of you who don't know, I'm Alan Wilson. I'm the Attorney General for South Carolina. I have standing with me Colleton Waters, who's the Chief Prosecutor in the State Grand Jury and the Chief Prosecutor on the Alex Murdaugh trial team. Go ahead just to kind of sum and tee up everything. Today, the South Carolina Supreme Court ruled in a 5-0 decision to reverse the murder convictions of Alex Murdaugh. Ruled in a 5-0 decision to reverse the murder convictions for Alex Murdaugh for the June 2021 murder of Maggie and Paul Murdaugh. The court based its decision on the conduct of then Colleton County Clerk of Court Rebecca Hill. As you know, this conduct involved her interactions with the jury at that time. As the court said in the order, this was conduct unknown to the state and other individuals. My office's position has always been that the conduct, while inappropriate and should never be condoned, was ultimately harmless as it related to prejudicing Alex Murdaugh's right to a fair trial. The Supreme Court obviously disagreed in its conclusion. While we strongly disagree with the Supreme Court, we respect its decision because that's how the process is supposed to be played out. So now we must look to the future. What does this decision mean going forward for this office? First, Alex Murdaugh is currently serving a 27-year sentence for the financial crimes that he has admitted to in a guilty plea that we secured against him, and he has also waived his appeals for those financial charges. Additionally, he pled guilty to federal charges about 5 months after he pled to the state financial charges. He received a concurrent 40-year sentence in addition to the state's charges. So Alex Murdaugh will not be getting out of prison for several decades. Currently, our office is reviewing the Supreme Court's order. We're meeting with members of our legal team and our staff. We're evaluating what our legal strategy will be going forward. As of right now, the state has 15 days to ask the state Supreme Court to reconsider its decision, and we have 90 days to appeal to the U.S. Supreme Court. However, it is currently my intention to seek a speedy retrial in the case against Alex Murdaugh. Obviously, I always say this with the court's current decision. We obviously recognize that all defendants have the presumption of innocence unless and until they are proven guilty in a court of law, and Mr. Murdaugh will enjoy that presumption at this time. Are there any questions?
Mr. Attorney General, your opponents in the governor's race are jumping on this, saying your office bungled the case. I know the court's decision pointed the finger at Becky Hill, but are you worried that this is going to affect your campaign for governor and will look poorly upon your records?
No, not at all. Obviously, the court has been very clear. People who have never actually been a prosecutor, been in law enforcement, stepped foot in a court of law, held the hand of a victim as they got a jury sentence read, have ever gone through this process. They can make all the political haymakers they want out of this, but at the end of the day, people were murdered. People were murdered at the end of the day, and if people want to make this a political issue, that just shows their character or lack thereof. This office and the men and women who worked in this office at that time and who will be working on this case going forward are some of the finest prosecutors, finest investigators that I have ever met. Whether they're at SLED, whether they're in this office or the law enforcement agencies that we worked with, they did their jobs. The Supreme Court even said that in its order, that the state of South Carolina did its job right. Obviously, this court gave us some guidance going forward in the next trial regarding how they would like to see evidence handled, or presented rather, but they placed this squarely on the shoulders of the former Colleton County Clerk of Court. Anyone who says otherwise is purely playing politics with a very, very serious issue.
Attorney General Wilson here or Walterboro, or do you know?
We would expect it would be in the same jurisdiction that it was originally tried.
Why? There were issues with the clerk of court in that court.
The clerk of court has been convicted of misconduct and is no longer the clerk of court.
So you don't expect any other possible issues in Colleton County?
Well, Colleton County is not the reason that the clerk of court did what she did. That was the clerk of court's decision.
Could she face any other charges as a result of this?
We're not going to comment on any other possible. Obviously, the case against the former Colleton County Clerk of Court was referred to another solicitor for review. That solicitor made criminal decisions regarding the totality of her conduct. She pled guilty to misconduct charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time. Yes, sir.
Did this ruling come as a surprise, and what can you tell to the people of South Carolina who might be worried about the cost of a second trial?
Well, first off, our office has always maintained, and we've never disputed, that the conduct Ms. Hill engaged in was inappropriate. We have always maintained that the conduct was harmless error. Obviously, if you, for those of you who watched the post-trial hearings, for those of you who saw everything unfold in real time, there were many, many, many witnesses who testified that this, I think 11 of the jurors testified in open court during that post-trial hearing that they did not believe that this affected their decision. We believe that it was harmless error, and so obviously when the court came to a different conclusion, it was obviously disappointing to me personally. I know it was disappointing to Creighton. It was disappointing to other members of our team.
And as far as the cost of a second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they have a right to have their case adjudicated in court even though they're not currently here. Their family members who they left behind have a right, for those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward. Seeking justice is the role of this office. Enforcing and defending the rule of law is the job of this office. It is the job of the men and women of this office, and that is what we have always held to.
Do you plan to prosecute the case any differently this time?
As I said a moment ago, Mr. Waters and I have been in consultation all day. He's been talking with members of our team here in the State Grand Jury Prosecution Division. We don't want to comment publicly on what our legal strategy would be moving forward. Obviously, there will be very little surprises to the general public as this case gets retried again. But obviously, we have a roadmap the Supreme Court has given us based on what they have put forward in their order. But again, I don't want to talk too much openly about what our legal strategy would be because we haven't gotten there yet.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done.
We're still in that window for 3 more months. So obviously it is something that we are contemplating all of our legal options, and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on our right to appeal are things that we're going to be talking about in the hours and days to come, and we will be making those decisions. Regardless of that, it is my current intention to seek a speedy retrial of this case.
With the documentaries and the different podcasts that are already out, do you think that will taint anything in the case or the retrial?
I mean, look, you always are concerned about the exposure a high-profile case gets, and that is always something you're concerned about. But obviously the process is designed and built to kind of cull that out, and obviously I trust the process and the system to help us get back to a court of law where we can get this information back to a jury.
One more question. How quickly do you expect you could be back to trial with this?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
You might not be Attorney General by that point.
Irrelevant. It doesn't matter who the Attorney General is. The Office of the Attorney General will still be here. Would I like to be involved in this case like I was the first time? Absolutely. But like I said, the men and women, many of the men and women who were on that original trial team are still in this office. Some have obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case is not going to be built on who the next occupant of my office is. It's going to be built on should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
I guess, Attorney General, there's been calls for reform of the system. You yourself have called for judicial reform. Given that the finger's been pointed at the clerk, are there any reforms you think should happen for clerks within the judicial system?
Look, the system worked when it came to the former clerk of Colleton County. Obviously, after the fact, unknown to us, as the court said in its order, her conduct was obviously made known. That was handled by the system. Other conduct that she engaged in, which was discovered long after the trial concluded, that ultimately led to her conviction for misconduct in office, was handled by another solicitor's office that I signed them that case. and that was handled appropriately, and she was convicted in a court of law. So the system addressed that individual.
And I know you're not going to speak about your strategy, but do you think the evidence that they pointed out that you spent too much time on the financial woes of Murdaugh, do you think that's going to have an impact on your trial going forward?
I mean, look, we have the benefit of hindsight now. We believed, and the court did say in its order that the evidence that we got in was permissible. They obviously provided us some guardrails to go back on remand to the original trial court where it will be tried, and they gave some guidelines and some guidance that we will obviously evaluate and use as a guide in presenting the next case. I'm happy, Creighton, if you want to take a moment, I'm happy to let you address that issue as well.
Yeah, I mean, absolutely. We, of course, were, aggressive about that evidence. But as you recall, we filed multiple pretrial briefs. We laid out our theory of the case. We put all that evidence on the table. And ultimately, Judge Newman heard it all and agreed that it was permissible. But this is part of the process. The Supreme Court, multiple times in the order, said that this was viable evidence of motive, but ultimately gave us some guidance about the extent. That's how it works. You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill, and then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called superbly competent and professional presentation by both the state and the defense. So these things are not 2 + 2 = 4, and we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
Mr. Waters, thinking back to January, in which arguments were brought before the state Supreme Court, was it a difficult or untenuous position to have to, in some ways, talk about Becky Hill and basically, in some ways, make sure that, to say it no other way, to kind of defend her in that hearing?
Well, again, whenever you try a case and you, as a prosecutor, like I mentioned, with double jeopardy, you have to, within your interpretation of the rules, be aggressive. And so we were expecting that. The one thing you don't expect is to ultimately have to address these issues with the clerk. As we presented to the court, and as the AG just said, we thought that Justice Toll got it right, that ultimately there was no effect on this verdict after 6 weeks of trial and all the evidence that was presented. Supreme Court saw it differently, and that's their prerogative to do so. So certainly that was not an issue that we were hoping for and expecting, and unfortunately that was the one where the Supreme Court hung its hat. But again, that's part of the process. You dust yourself off, you get back up, you take a fresh look at it, and then you go do your job, and that's what we plan to do.
I want to close by first off just thanking the team in the Attorney General's office. Obviously, we're disappointed, but I couldn't be prouder of the job that Creighton and his team did. We lived through 6 long weeks 3 years ago, and we believe we did a good job for the people of South Carolina. We believe we represented the criminal justice system very well. A lot of people didn't think we could get a conviction, and we got it. Unfortunately, someone, unbeknownst to us, engaged in conduct that the Supreme Court believed prejudiced a defendant's right to a fair trial, and Supreme Court made the decision. While we don't agree with that decision, we respect that decision, and we're going to comply with that decision, and we're going to follow the rules given to us by the court, and we're going to move forward. Again, we will keep you all up to date as much as we possibly can on all the developments that come out. Obviously, we have a lot of work to do. We have to reevaluate, we have to review, we have to meet with people and make decisions in the coming weeks. Again, our hope is to get this case retried by the end of the year, but obviously, time will tell if we're able to do that, but that is our intention at this time. I want to thank all of you for giving us the opportunity. I'm sorry it was late in the day, but we had to absorb everything. We had to meet with a number of people, and we wanted to be able to give you this information as quickly as we possibly could. So thank you so much. I hope you have a wonderful day.